Hello students, now your topic for today is chapter 5 under the Rajasthan Rent Control Act 2001. So, this chapter deals with the constitution of tribunals, procedure for revision of rent and eviction, appeal, and execution. Section 13 deals with the constitution of a rent tribunal. So, the constitution of a rent tribunal over here means that the state government will constitute the number of rent tribunals and the places that are necessary by it by giving a notice to the official gazette. And two or more rent tribunals are constituted for any area, and the state government may by general or special order regulate the distribution of business among them. A rent tribunal will consist of one person only, who will be appointed by the High Court, and no person will be eligible to be appointed as a presiding officer of the rent tribunal unless he is member of a Rajasthan Judicial Service. Notwithstanding anything that is contained in subsection 3, which is talking about the presiding officer, that should be one. The High Court may authorize the presiding officer of one rent tribunal to discharge the functions of the presiding officer of the another rent tribunal also. Then section 14 deals with the procedure for revision of rent. So the landlord may seek revision of rent under section 6 or section 7 by submitting its petition before the rent tribunal, that will be accompanied by affidavits and documents if there is any. And on filing such kind of a petition, the rent tribunal will issue a notice that will be accompanied by copies of the petition, of the affidavit, and of the documents to the opposite party, fixing a date that is should not be later than 30 days from the date of issue of notice. The opposite party may file reply affidavits and documents after serving the copies of the same on the petitioner within a period that should not exceed 30 days from the date of service of notice. The service of notice shall be evicted through process server of the tribunal or civil court, as well as by registered post acknowledgement due. Notice duly served by any of these methods shall be treated as a sufficient service. Then the petitioner may thereafter file a rejoinder. The rent tribunal shall thereafter fix a date of hearing. The rent tribunal, during the course of such kind of a hearing, may hold such summary inquiry as it deems necessary, and it can fix rent as per formula laid down in section 6 or section 7 and issue a recovery certificate indicating the date from which such rent shall be payable. The petition shall be disposed of within a period of 150 days from the date of service of notice on the tenant. Now, section 15 is about the procedure for eviction of tenant. So, the landlord or any person who is claiming possession shall file a petition before the rent tribunal, and such petition shall be accompanied by affidavits and documents, if any, upon which landlord or person claiming possession wants to rely. The rent tribunal, upon filing of petition under subsection 1, shall issue notice accompanied by copies of petition, affidavits, and documents, if any, fixing a date not later than 30 days from the date of issue of notice, requiring the tenant to submit reply accompanied by affidavits and documents, if any, on which the tenant relies. The service of notice shall be effected through process server of the tribunal or civil court, as well as registered post acknowledgement due. Notice duly served by any of these methods shall be treated as sufficient service. The tenant may submit his reply, affidavits, and documents after serving the copies of the same to the petitioner within a period that should not exceed 45 days from the date of service of notice. If the petitioner may thereafter file rejoinder, if any, after serving copy to the opposite party within a period of 30 days from the date of service of reply, the rent tribunal shall thereafter fix a date of hearing which shall not be later than 180 days from the date of service of notice on the tenant. The petition shall be disposed of within a period of 240 days from the date of service of notice on tenant. The rent tribunal, during the course of such hearing, may hold such summary inquiry as it is necessary, and where the rent tribunal decides the petition in the favor of landlord, it should issue a certificate for recovery of possession from the tenant, and the certificate that is issued under this section shall be executable for a period of 3 months from the date of decision. Now, section 16 is about the procedure for recovery of immediate possession. So, in this, the landlord or any person who is claiming a immediate possession has to file a petition before the rent tribunal, and such petition should be accompanied by affidavits and documents upon which the landlord or the person who is entitled to seek immediate possession wants to rely. The rent tribunal, upon filing such kind of a petition that is under subsection 1, has to issue a notice that should be accompanied by the copies of the petition, affidavits, and documents, fixing a date that should not be later than 30 days from the date of service of notice, requiring the tenant to submit his reply and accompanied by the affidavits and document if he has any on which the tenant relies, and the service of notice should be effected through process server of the tribunal or civil court as well as by registered post acknowledged due. Notice duly served by any of these methods shall be treated as sufficient service. The tenant may submit his reply, affidavits, and documents after serving the copies of the same on the petitioner within a period of not exceeding 30 days from the date of service of notice. The petitioner may life joinder, if any, after serving copy of the same on the tenant within a period of 50 days from the date of service of reply. The rent tribunal shall thereafter fix a date of hearing which shall not be later than 90 days from the date of service of notice of the tenant. The rent tribunal, during the course of such hearing, may hold such summary inquiry as it deems necessary to determine whether the petitioner is a landlord as categorized under the above sections, and the certificate that is issued in section 5 shall not, subsection 5, shall not be executable for a period of 3 months from the date of decision. Now, Section 17 is fixing of a date of appearance of parties before appellate rent tribunal and supply of the copies of the final order. So, in this, the rent tribunal has to while finally deciding a petition in which it is not proceeding ex parte against any party, has to fix a date beyond 2 months but not beyond 6 months, and of its decision for the appearance of the parties to the petition before the appellate rent tribunal to which the appeal against its final order lies, and the parties to the petition shall appear before such appellate rent tribunal on such date to receive the notices of the appeal, if any, filed against the final order of the rent tribunal. The date that is so fixed shall be mentioned in the final order passed by the rent tribunal, and the copy of the final order shall immediately after the pronouncement of the order be delivered to the party against whom the same is made. And if the final order is partially against one party and partially against the other party, and both the parties may prefer appeal against the final order, then the copy of the final order shall be delivered to both the parties. The copy of the final order shall bear the endorsement under the seal of the presiding officer, and that the same is being supplied under this provision, and the party preferring an appeal may file such a copy along with his appeal. Now, Section 18 deals with the jurisdiction of the rent tribunal. So, notwithstanding anything that is contained in any other law for the time being in force, and in areas to which this act extends, only the rent tribunal and no civil court shall have jurisdiction to hear and decide the petition relating to the disputes between the landlord and the tenant and the matters that are connected therewith and annex thereto filed under the provisions of this act, provided that the rent tribunal shall, in deciding such kind of petitions to which the provisions contained in chapter 2 and 3 of this act do not apply, have due regard to the provisions of Transfer of Property Act 1882, and provided further that nothing that is contained in this section shall be deemed to empower the rent tribunal to entertain its petition that is involving such dispute between the landlord and the tenant, to which provisions of the Rajasthan Public Premises Act 1964 and Rajasthan Premises Ordinance 1949 apply, where the petition only for the recovery of unpaid rent or areas of the rent is filed. The time, schedule, and the procedure enumerated in Section 14 shall mutatis mutandis apply to such petition, where the petition for recovery of possession is styled in respect of the premises or tenancies to which the provision of Chapter 2 and 3 of this Act do not apply. The time, schedule, and procedure enumerated in Section 15 shall mutatis mutandis apply to such petition. A petition shall be instituted before the rent tribunal within the local limits of whose jurisdiction the premises is situated. Now, Section 19 deals with the Appellate Rent Tribunal, appeals and limitation thereof. Section 20 deals with the execution of the orders. So in this, the rent tribunal shall, on application of any party, it should execute in the manner that is prescribed a final order or any other order that is passed under this act by adopting any one or more of the following modes that are mentioned below. The tribunal may, in order to execute the final order or another order should pass that is passed under this act, require a help of a local administrator or a local body or the police. The tenant does not has to vacate the premises within 3 months of the date of the issue of certificate for recovery of possession. He shall be liable from the date of the issue of certificate for recovery of possession to pay mesne profits at the rate of 2 times the rent in case of the premises let out for residential purpose, at the rate of 3 times the rent in case of the premises let out for commercial purpose, and at the rate of 3 times the rent in case the certificate for recovery of immediate possession has been issued under Section 16. Then the rent tribunal shall conduct the execution proceeding in relation to a final order or any other order passed under this act in summary manner and dispose of the application for execution made under this section within 45 days from the date of service of notice on opposite party. Now, Section 21 deals with the procedure and the powers of the rent tribunal and the appellate rent tribunal. Section 22 is talking about the model forms. Section 21A is talking about the procedure and the powers of the rent tribunal. That's all. Thank you.